Hello, everyone, and welcome to Internet Law Review. For today's story, we have the case of John Doe versus Rhodes College. This is a Title IX case wherein John Doe, a male plaintiff, was accused of sexually assaulting another person at the school and was expelled. Rhodes College is a private college located in Tennessee, and that aspect is actually quite important because this trial court decision gave an injunction requiring the college to readmit the plaintiff. Now, that's unusual because due process issues, on which the court relies, normally apply only to the government. Only the government is required to give due process. But the court here held that Title IX implicitly requires a due process guarantee and that a private college is bound to that due process guarantee. So, to the best of my knowledge, this is the first time a court has said that a private college under Title IX is required to give due process to a person accused of a sexual offense. So we're going to read a little bit about the background of this case and then read the law and see what the court has to say. So let's get started. This case concerns alleged violations of Title IX of the Civil Rights Act of 1964 and breaches of contract. Plaintiff is a male that was a senior at Rhodes College, scheduled to graduate in May 2019. The event was also attended by CS. CF was plaintiff's date for the events. That evening, CS consumed a large quantity of alcohol, smoked marijuana, and used cocaine. The plaintiff contacted CS's friend, CC, to come and pick her up. When CC arrived, CS told her, "They raped me," and that she wanted to go to the hospital. Upon arriving at the hospital, CS changed her mind and said she wanted to go home. The Title IX investigative report states, in relevant part, as follows. Witness, CC, stated CS was very non-responsive. Witness stated CS was very subdued and lacked energy. Witness stated CS's eyes were closed, but she could move one arm instead of speaking. Witness said that she and another female student asked CS what happened and started using yes or no leading questions. Witnesses stated they started to list questions to figure out who raped her. That is, was it a freshman, sophomore, junior? Witness stated CS gave a thumbs up to it being a senior, a thumbs up to it being JS, and a thumbs up to it being ZW. Witness also stated that when she was asked about anyone else, CS motioned that she was unsure. Witnesses stated that they asked CS if the guys had sex with her, and CS gave a thumbs down. The next morning, CC reported CS said that she thinks she was raped, but she doesn't know if she's misremembering. A sexual assault kit was administered, and the Memphis Police Department was contacted, and CS and her friends gave statements to the sex crime unit. The police department then came to question students at the college. The week following the alleged event, an organization called Culture of Consent began protesting about topics related to sexual assault and investigations thereof. These protests were directed to fraternal organizations, which are necessarily male, the Rhodes administration, and to the student body. The organization also directed protests to Rhodes football players. The Rhodes Title IX investigator, Emma Davis, interviewed 14 witnesses, excluding plaintiff and CS. Not one witness with personal knowledge corroborated that CS was raped. The only evidence supporting such were CS's statements made to CC and DP while incapacitated and intoxicated. Additionally, there was one witness named JH that told the investigator he was there and he would have seen if anything happened to CS, but that no sexual assault or inappropriate conduct took place. Rhodes, the college, charged the plaintiff and ZW on April 5, 2019, and held a hearing on April 17, 2019, which one will note is 12 days later, to determine whether they violated defendant's sexual misconduct policy. CS, that is, the victim, did not attend or participate in the hearing and was not subject to any questioning by the decision panel or subject to cross-examination of any kind. So that means the principal witness, the alleged victim, did not offer any testimony or any other evidence, and she was not available for cross-examination, so that obviously raises due process concerns. No witness testimony supported CS's contention through any form of direct evidence. Without warning or notice, the Title IX coordinator introduced additional evidence into the proceeding. That's always questionable when you're doing something without giving notice to the other side, because in trials, under at least criminal law, there's stuff called Brady material, and this would have to be disclosed. So, of course, making notice of the fact that the defendant was surprised here. And this additional evidence was a one-page of a medical examination indicating CS had superficial injuries to her rectum. The panel was asked to take this as dispositive of the allegation that CS was actually raped. CS was not present, and accordingly, she could not be asked about the causes of these injuries. Female witnesses were allowed to testify about hearsay statements, which are statements offered by someone else as though they were true, allegedly made by CS during her intoxication, but the college, Rhodes, did not call JH, a male witness who was present around JS virtually the entire evening, who said no sexual misconduct took place. As a result of the above, the plaintiff filed this action, alleging that the college violated Title IX based on an erroneous outcome and selective enforcement theory, and that defendant is in breach of contract. The plaintiff additionally seeks to enjoin defendant from both enforcing its decision to expel plaintiff and refusing to confer the degree. With the factual background out of the way, let's talk about the legal standards. As the court just mentioned, this is an issue dealing with an injunction. And as stated here, the standard for determining whether to grant a temporary restraining order is the same as standard for determining whether to grant a preliminary injunction. Courts must examine 4 factors in deciding whether to grant a preliminary injunction or temporary restraining order: whether a movement is likely to succeed on the merits, whether the movement will suffer irreparable injury in the absence of an injunction, whether the injunction would cause substantial harm to others, and whether the injunction would serve the public interest. Title IX of the Education Amendments of 1972 provides, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or subject to discrimination under any education program or activity receiving federal financial assistance." Causation sufficient to state a Title IX discrimination claim can be shown by statements by members of a disciplinary tribunal, statements by pertinent university officials, or patterns of decision-making that also tend to show the influence of gender. Notably, the non-appearance of CS appears to have been a significant denial of due process. Obviously, the panel thought CS's appearance at the hearing was unnecessary. It seems the panel resolved credibility issues without seeing or directly hearing from CS. Moreover, with CS never appearing and presenting live testimony, plaintiff was never given an opportunity to cross-examine her directly through his agent or otherwise. Thus, plaintiff presents facts sufficient to cast some articulable doubt on the accuracy and reliability of disciplinary proceeding outcomes and satisfies the first consideration of erroneous claim under Title IX. So from this paragraph, we can see some of the key differences between a hearing at a college to determine if you should get expelled and a trial, either civil or criminal. Under the law, you have a right to confront your witnesses and you have a right to engage in cross-examination, and the jury or other fact finder has a right to look at the people making the accusation to assess their credibility, hear the words coming out of their mouth, and see whether or not it rings true in their judgment. In this situation, the college did not call CS, the tribunal, the judges, didn't hear from CS, no one had the opportunity to question CS, and all the statements from CS would be what we would call hearsay if they were offered in a trial. So the nature of the testimony is significantly more suspect and significantly more questionable during this hearing than it would be during a legal proceeding at a court. As a result of these discrepancies, the court is finding here that there's some doubt as to the accuracy and reliability of those proceedings because of this failure of due process. The court continues. As an initial matter, the court notes that the public attention caused by protests and social media posts of culture of consent, apparently lodged at fraternity members, which are necessarily male, at the college, that play for the school's football team, may have put pressure on the college to confirm that it took sexual misconduct allegations seriously. Indeed, as an institution subject to Title IX, defendant could lose federal aid if they're found to be non-compliant with Title IX. So the court is noting here the danger of a mob mentality. When the mob is calling for someone's head, if someone is giving it to them, the trial is suspect. The court continues. The record tends to show that the defendant credited exclusively female testimony from CS's witnesses and rejected all male testimony from plaintiff and or his witnesses. Plaintiff's amended complaint, that is, before this court, the trial court, alleged that the female named EM was clearly implicated in the sexual assault, but was not charged or investigated like plaintiff and ZW, potentially showing sex bias. Thus, plaintiff alleges sufficient facts showing a substantial likelihood that the decision-making process in this case resulted in a flawed outcome. Plaintiff's allegations also tend to show the influence of gender bias. Plaintiff asserts that the disciplinary action taken against him has already damaged his reputation and may affect his ability to enroll at other institutions of higher education and pursue a career. As noted by the Ninth Circuit, being labeled a sex offender by a university both has an immediate and lasting impact on the student's life. Moreover, plaintiff faces the immediate and irreparable harm that a sexual misconduct finding will negatively impact his academic and professional reputation. Defendant, that is, the college, submits that mandating it to confer a degree to plaintiff would require plaintiff to return to campus without a substantive determination of his innocence and ultimately put the campus community at risk and make victims less likely to participate in Title IX investigations. It is true that there is a public interest in educational atmospheres that are conducive to studying and learning for students. Colleges and universities are afforded great latitude in administering their rules and regulations to achieve such a goal. Simultaneously, however, the court cannot conclude that such interests outweigh that of ensuring that the educational institutes comply with procedural due process and Title IX when seeking to achieve such an educational environment. So the federal court has ordered that the plaintiff, John Doe, be reinstated. They did not order that the college give the degree, however, because he has not met all the requirements for the degree in terms of meeting the academic requirements because he was expelled. So obviously, as to that part of the relief, that's premature. But this case is extremely notable because, to the best of my knowledge, it's the first case that says a private university, rather than a public university, must give students accused of sexual misconduct due process. Now, exactly what that means for a college is not exactly what it means for a court. There are different standards to be applied. But whatever it means, the court says that this went too far. Not only did the alleged victim not have to testify, not give cross-examination, but the college only gave credit to any of the female witnesses, did not call male witnesses who had rebutting testimony, and did not consider the plaintiff's testimony itself in reaching its determination, thus reaching a due process violation. It is very likely that this decision will be cited by other courts as they struggle with these Title IX issues, so I would expect that other courts in other parts of the country will say that their private colleges must likewise give due process to their students as well. So this should be a pretty watershed case going forward. But for now, my friends, this is all. I hope you're well. Until later, cheers and goodbye.